Thank you, everyone. Please be seated. We are here this morning for the submission of 4 different cases. The first case of Delaney versus Second Injury Fund is hereby submitted without oral argument. Our first oral argument this morning is Clark versus State of Iowa, and it looks like the parties are ready. We'll begin with Mr. Ranscht.
Thank you, Madam Chief Justice, and may it please the court. Over a decade ago, one of you said in a legal malpractice case, it will be hard to draw the line in the next malpractice case against a criminal defense attorney. Well, here we are. Here's that case. Now you have to draw that line, but the good news is it's not really that difficult. The line is drawn at illegitimate acts an attorney undertakes, as set forth in Lawrence and in Miranda, and applied expressly by the Court of Appeals in its McFarland decision. Below, the district court did not cite McFarland or its express statement that Miranda requires more than ordinary negligence to authorize emotional distress in malpractice cases. And a different line was also crossed below when an expert witness told the jury here that the plaintiff couldn't even be here, couldn't even be in court, couldn't bring the claim unless a judge had already found the defendant attorney, that's former public defender John Robertson, provided ineffective assistance. That undermines the previous appeal in this very case, which determined the standards are neither interchangeable nor preclusive.
You were reviewing for abuse of discretion. Isn't the trial court in a better position to judge whether a mistrial should have been granted?
Better. The standard is on appeal. The appellate court is slower to interfere with granting a mistrial than with denying one. And so this was a trial scheduled for a long time, but it was the first live witness after the underlying criminal trial. This was day 2 of what ended up being a 5 or 6 day trial. The serious and severe consequences of granting a mistrial in the criminal context are missing here. There's no speedy trial deadline. There's no double jeopardy that has to attend. There is less risk of re-traumatization from potential alleged victim testimony. And because these are unique cases with PCR and negligence interconnected, courts have to be extra solicitous, careful, vigilant about conflating the two. We know the standard's not the same.
Make a difference? The trial court immediately instructed the jury to disregard former Judge Bennett's testimony on that point, and then offered a curative instruction, and then in the standard jury instructions later, they're again told to disregard evidence that the court told them not to regard.
Mistrial and not just a limiting instruction, that was a half measure. That was better than saying nothing. Limine orders, which is what generated the objection and the motion for mistrial, are preliminary by definition, but it undermines the purpose of having the preliminary order in place if we let witnesses blaze through them, intentional or not, and just solve them with a limiting instruction, especially witnesses with as many credentials as Mark Bennett. The transcript reflects 24+ pages of building his credentials, and this is the first substantive question on the actual case after all of that. I also think that there are certain things that can't be unrung. So in some instances, maybe a limiting instruction is appropriate. In this case, which has already generated on this question, the interplay between PCR and negligence, a summary judgment ruling from the district court, a reconsidered summary judgment ruling that changed, and an interlocutory appeal up to this court, all shows that issue is fraught with danger, and the district court recognized that on the front end by putting the limine order in. So it is just the unique nature of this case that means that a limiting instruction wasn't enough. Yes, the state accepted that, but it was a half measure. The state wanted more.
More detailed curative instruction would have just rung the bell again.
Rung a second bell. Pick your.
Even if we agreed with you that that required a new trial, we'd still need to reach the other issue of, do you have to prove illegitimate conduct to recover?
I think that is true. But the case law builds through from Lawrence to Miranda to McFarland. Again, McFarland says it expressly about Miranda. It requires more than ordinary negligence. And the district court was presented with McFarland, didn't rely on McFarland, whether that's because it's...
Appeals unpublished, right? Okay, all right, so let's move on. You say illegitimate means, doesn't mean, at least as I read your reply brief, a strategy or an approach that had a 99% chance of failure, but it's more than negligence. So what is it? Where do we draw the line?
Something that can't succeed. I know that the standards here are different, but Miranda also authorized the emotional distress damages and punitive damages, and it held that the conduct in that case was willful, wanton, reckless. Any of those standards, thus, would also satisfy the something more, the illegitimate requirement that Miranda recognizes. It could be something less. One example is in Miranda, right? The lawyer told his clients, this has a 99% of success, it's gonna work. He really knew that it wouldn't, or at least shouldn't. I think you might be able to get to that difference between illegitimate and punitive, and still have it be illegitimate if he said, hey, look, you could do this. Your relatives, you could go back to Ecuador. Your children technically don't qualify for this form, but it has worked in the past. It shouldn't work, but it has. I think there's a risk here. I think you might be able to get there, that's still illegitimate.
Tweak the set of facts in this case, just that you think it would go over that bar. What would make it willful or wanton? Because the facts in this case are pretty outstanding. So persuade me that it's not willful wanton.
So there's a couple other cases from other jurisdictions that...
This case, what would you do? What do you think would push it further? I mean, what's an example of something that would be willful or wanton with these sets of facts? I mean, not even going to the school to investigate into it, not telling them about a deposition. I mean, those seem pretty far extreme. What would have taken those over that limit?
Not showing up to court or hearings or things like that. Not presenting, so not just the character evidence that was disputed here, but an undisputed alibi or an undisputed thing that showed unequivocally that the defendant wasn't in the place at that time. I've got my credit card receipts from the In-N-Out Burger in California where I was when this supposedly happened. It's something like that would push it over the line.
Section 13B9 provides that public defenders can be liable for damages as long as there's proof of proximate cause, but it doesn't distinguish between different types of damages. Can't we infer from that the legislature authorized typical negligence damages because there are many provisions of the code that distinguish between punitive, exemplary, emotional distress, economic loss, and I don't see that distinction here.
I think that the legislative authorization, though, still has to be read as we authorize damages in accordance with law. And what else is law? Lawrence, Miranda, and the common law decisions of the court. So whether they intended specifically to authorize emotional distress damages, I don't think that's visible from the language of the statute, and I think you have to read the language of that statute in light of the other applicable law.
Is from a civil lawyer like Saeed in this situation. If Saeed had done the comparable thing, you can't get it from a criminal lawyer. Is that your argument?
I think that is one way you could read it, yeah.
Legally, I guess I'm struggling with the framework. Other than punitive damages, we don't usually link the availability of the type of damages based on the tortfeasor's conduct, right? Like if it's negligence, then that opens up a whole kind of box of damages that are available. And I don't see why that should make sense here, that if the lawyer does a really, really bad job, then the plaintiff can get emotional distress damages. But if it's only kind of a bad job, then those damages aren't available. Theoretically, why does that make sense to link the damages to the conduct when usually conduct is about liability thresholds and not damages?
Because when you say we don't usually, that's other negligence cases. Malpractice cases are different, as you've said. Normally in malpractice cases, the general rule is you don't get emotional distress damages. So it's blending, your question blends other contexts outside of legal malpractice when the case is already recognized that there's a special consideration, specifically in malpractice cases.
Well, in tort law is you need a physical injury to get emotional distress, is to avoid a flood of false claims or they're too easy to just make up. But here we have somebody who spent 6 years in prison. Does that satisfy the personal injury or physical injury requirement when he's lost his liberty?
That satisfies what I understand to be the two-part framework from Lawrence, right? We have the nature of the transaction and the relationship, and then we have the acts themselves. So we don't award emotional distress simply because of the emotional nature of the transaction or the high stakes of the transaction, right? We also evaluate the conduct. The fact that prison is at stake, I think we can agree that maybe satisfies what I call question one of Lawrence, but we're here about question two.
The state's the defendant in this case because the lawyer was a state employee. What happens with contract? I mean, we have to be mindful of the precedent we set today. May make it easier to sue court-appointed private counsel. Does the state indemnify a court-appointed private lawyer?
It indemnifies only state employees. A private lawyer under the administrative code has the force of law, is expressly not considered a state employee for purposes of the Tort Claims Act.
A crisis in getting lawyers to agree to go on the court-appointed list. They're really falling short. If we affirm the judgment in this case, would that deter private lawyers from doing criminal defense work?
Effect. That's something that Justice Zager highlighted in his Barker dissent. That is something that the New York Court of Appeals highlighted in its Dombrowski case, which is factually, I'm not going to say on all fours, but still I think materially similar here, where a plaintiff obtained habeas relief, sought damages and malpractice, and the New York court said, look, this has a chilling effect. That's one reason we're not going to authorize emotional distress damages here. So yes, it could be a danger. I want to talk about whether this is a question of law or question of fact. Miranda itself was decided on a directed verdict at the district court. That district court concluded emotional distress wasn't available as a matter of law. So that suggests no jury finding here is required, and that the availability of certain categories of damage is a legal issue for the court. And I think that procedural posture is what drove the district court here to say, hey, the parties have maybe proposed some instructions on this, but I'm gonna pull those. I'm not gonna give those to the jury. I'm gonna reserve this for a legal determination. It also shows, though, Miranda also shows, though, that a plaintiff can seek economic damages in legal malpractice. There it was the cost of the services provided, and indeed the dissenting opinion there points out that was the amount of fees the plaintiff had paid. Here, docket 225, that's the limine order, but it actually addresses several different motions that had been pending, points out that Clark made an election to seek only emotional distress. The state had proposed lines on the verdict form for other forms of damages, lost wages, medical expenses, cost of therapy, and that was a litigation choice, which is exactly what happened in McFarland, but it's not something the state forced. It doesn't make damages always unavailable.
Is it, if any, that the legislature has provided for a $50 a day payment if for wrongful convictions, but that requires a finding of actual innocence? Could Clark have sought that amount in addition to his other damages?
The case law is that a plaintiff has an election. They can either seek malpractice damages without having necessarily to show innocence as a prerequisite, that's what Barker stands for, or they can not have to show negligence, but show innocence in the statutory framework. So those are, my understanding of the case law is that a plaintiff has to elect them, and but that concern is what animated Virginia's decision to deny non-pecuniary damages in a malpractice case. I see my time's up. Thank you.
Thank you, Your Honor. May it please the court, counsel. Miranda versus Said did not change the law as was pronounced in Lawrence v. Grindy. Lawrence v. Grindy recognized an exception to the rule that emotional distress damages must be accompanied by a physical injury. It recognized that exception based upon a majority of jurisdictions having decided that when a contract is infused with such peculiarly personal matters, and where violation or negligence in undertaking the purpose of that contract is likely to result in severe emotional distress, that the court will recognize that that emotional distress is a recoverable element of damage. And the court in Miranda versus Said traced the reasoning for that rule back to Hadley versus Baxendale and the idea that parties should be responsible for the anticipated consequences of their negligence. So Lawrence was decided nearly 30 years ago. Miranda applied Lawrence nearly 20 years ago. And in applying Lawrence, the court in Miranda said on multiple occasions, we are not departing from the framework set forth in Lawrence.
Your view, I mean, to me, it's difficult to conceive of a situation where somebody who ends up being incarcerated where they shouldn't have been would not suffer severe emotional distress. So is it, in your view, any case of malpractice against a criminal defense lawyer where the plaintiff had ended up going to prison that emotional distress damages are appropriate?
There's a hurdle in this case, and that hurdle is that a criminal defendant, in order to bring this type of claim, has to go through a PCR process, and they have to prove ineffective. So it won't be any case.
Assuming that hurdle.
Which I'd point out, and we made the mention in our brief, and I think the trial court made mention in its order as well, that hurdle is rarely overcome. But assuming that hurdle is overcome, and then the defendant, the criminal defendant turned plaintiff, will have to prove negligence.
To be overcome if they're going to be released before the end of their prison term, right? Okay, so, I mean, you have that situation. Is there any situation where the criminal defendant would not be, who has a successful PCR, which results in their release from prison, would not be entitled to pursue damages for emotional distress against their lawyer?
Prove negligence, of course, and they would have to prove causation. So they could pursue those damages, but whether or not they would be entitled to them depends on whether they meet the burden of proof. And the burden of proof builds in protections, especially as it relates to causation. And in this case in particular, the jury was asked, did Mr. Robertson's negligence cause the conviction?
There are differences between ineffective assistance and negligence, and we talked about that before. But causation is one of the elements of ineffective assistance. So haven't they already established that?
Requirement, as I understand in the negligence case is more strict, because under the Strickland two-part test, the prejudice doesn't have to be more probable than not. It just has to be reasonably likely. But in the negligence standpoint, it has to be a but for. Except for this negligence, it wouldn't have happened. So it's actually a more difficult standard to show the causation in a negligence claim than it is in an ineffective assistance claim. And the jury here decided that that burden was in fact met. I think that
that point, isn't the bar a little bit higher? I mean, doesn't there have to be some illegitimate action? Isn't that what Miranda says?
those words are used in Miranda, but that's not what Miranda says. If you read the opinion in total, multiple times, I think 3 or 4 times, the court says, we don't need to depart from the framework set forth in Lawrence. We are applying Lawrence. These facts fit squarely within our decision in Lawrence. The reason the words illegitimate show up in the Miranda case is, and we looked at the briefs submitted by the parties there, they were citing heavily DePape, which is a federal court case that was decided in the immigration context. And in that case, Judge Bennett said, you know, there may be emotional distress that accompanies a legitimate effort in the immigration context, but that would not be compensable. It's only where there's negligence. And so when the court in Miranda versus Said is saying, hey, here the negligence was an illegitimate conduct with no possibility of success, the court was merely defining what the negligence was in that case.
It says, I mean, at the end, I mean, there's a lot of discussion about a lot of things, which is unfortunately the way all of us on this court tend to write our opinions. There, a lot of them are, except for the chief and maybe Justice McDermott and Justice May. I think there's some others of us who write longer ones. Some of the others I think we write long, but there's a lot of winding up. But then at the end we say he's talking about emotional damages in this case. And there he does say again and again, it's limited to when there's this illegitimacy standard.
I read the case differently. Because of the things I mentioned, and it's mentioned in our brief too, the multiple references back to Lawrence, and also because of this reason, it wouldn't make sense, right? It wouldn't make sense because if you were pursuing pecuniary damages, which are an element of damage available in this claim, you only have to prove negligence. The defendant concedes that. But in this case, emotional distress damages are undoubtedly, indisputably likely to occur, and yet for those damages, which are wrapped up in the same conduct, the same event that allows for recovery for punitive damages, the state would have a higher standard, which it creates a dichotomy that frankly doesn't make any sense to say that the same conduct requires 2 different standards to recover one type of damage versus another. And the court's...
Clearly, the court, I mean, we were aware of jurisdictions that don't allow those kinds of damages at all in legal malpractice claims, and we were trying to reach a compromise. And I mean, here's what you know, the chief said. He said, it is not just the nature of the relationship that supports emotional distress damages, but the high likelihood of such damages from negligent acts engaged in by the lawyer. The duty arises when those acts are illegitimate and, if pursued, are especially likely to produce serious emotional harm.
And I believe that again, is a reference to what happened in that case and what was argued, as opposed to setting a new standard and a new bar for these kind of claims. And there's reasons for that. One is that the court in Miranda said, hey, we are going to avoid the temptation to create a different standard for lawyers than that set for any other professionals. And for any other professionals, if you look at the history of the development of the law allowing emotional distress damages and these sorts of situations, negligence is all that's required. And in this case, in Miranda, the court's saying, hey, we're not going to adopt a higher standard for lawyers. And one of the reasons is the court looked at this chilling effect and said, we don't see it. It cited the Holiday versus Jones case, and it cited other cases saying, we don't see that restricting an element of damage or providing a higher standard is somehow going to affect the availability of lawyers. That would be an anecdotal sort of decision that's not really supported by evidence. And the reason I say that is since Lawrence and since Miranda, there hasn't been a flood of cases before the court alleging that a public defender should be allowable for the emotional distress caused by their negligence. And these cases are decades old.
So, because your point about anecdotal issues and sort of lack of empirical support, I think the court does actually think it understands the practice of law and what incentives are on lawyers, and whether we're right or wrong about that is besides the point. But I'm just reading this, and the chief is talking directly about awards for emotional distress damages against attorneys may have a chilling effect on the practice of public interest law, specifically addressing that problem, and then going straight into this issue of, well, the issue of emotional distress damages, that duty is only going to arise when acts are illegitimate. It's hard for me to not see that as something different than just saying, oh, emotional damages are available just for negligence. And I just like your help with that part of the opinion.
And I'll try to help you. When talking about the chilling effect, they noted that that has been an argument that has been made, that there could be this potential chilling effect. But what the court said in regard to that, it quotes, sorry, Your Honor, let me get to this particular page.
33.
And unfortunately, what I have is the notes with in my notes with that reference, but I will get there shortly. So this is what the court cites with approval, that we are unwilling to say as a matter of law that the elimination of a single element of damage would improve the legal representation of public interest clients. Or conversely, that failing to limit damages will decrease the quality of representation. And as a policy matter, isn't it important for the court to, as required by Supreme Court precedent, there needs to be effective assistance of counsel in criminal cases. Effective assistance of counsel is a constitutional right. And so,
the criminal context. So let's take Chapter 232 in family law cases. If we were to adopt your position, how would that rule apply in those cases?
apply the same as it's announced in Lawrence and Miranda, that there has to be a very deeply personal issue at matter involved in this contract, and then they would have to be a proof of negligence. I think that there are instances, and I think there's safety built into the standard, and that the jury gets to parse out cause. That's really important. In family cases, in criminal cases, in these cases where, in the immigration context too, frankly, there's already a lot of emotion going on, and I think the dissent in Miranda versus Said acknowledges some of this, that there's already a lot of emotion involved in a family dispute. The jury, we believe, and I posit, is capable of parsing out whether or not the emotion caused, the damage caused by negligence is different and more than what previously exists. The jury's capable of doing that, and they're only going to award damages for emotional distress if we trust them to follow the law, which they're assumed and presumed to do as members and citizen jurors. Then they'll only award those damages for the emotional distress caused by the negligence, not for any damage, emotional distress that may pre-exist based upon the nature of the relationship, because they're required to say that the damages are only exist or wouldn't exist except for the negligent conduct that is being discussed in this case. And so I think that's a safety built into this test.
Concern that if we allow, if we affirm this jury verdict, it will deter many lawyers in the private sector from signing up for court-appointed work. The state won't back them up, won't defend or indemnify them if they're sued for malpractice. their malpractice rates may well go up, and for the $70 an hour they're paying, they may just decide it's not worth the risk of financial ruin and go do something else. And then we have a crisis of lack of attorneys doing criminal defense work.
My response, Your Honor, is respectfully, it hasn't happened. This case is coming before you after this precedent has been existing for 20 years.
People read it as requiring illegitimate conduct, a high bar to clear, so they're not too worried about it.
Addressing that issue, the illegitimate conduct, as I've mentioned, is related to the conduct that occurred, the negligence that occurred in that case. But it also would be a gradation of negligence, right, which this court, and I mentioned in our brief, for over 100 years has resisted applying different grades of negligence. And that's why I don't think that they did so.
Law is full of situations where we require gross negligence or willful and wanton conduct either to avoid a statutory immunity or to allow a lawsuit against co-employees in other situations.
Cases of willful and wanton misconduct, this court has already held in prior cases that intentional infliction of emotional distress is available in claims against juries. So that conduct is covered by a different cause of action, and applying a higher standard here of illegitimate, or as the state would define it, unlawful conduct, essentially erases the ability to obtain negligence unless there's willful and wanton misconduct, which is an intentional tort already available, Your Honor. So a ruling that required more would essentially erase the availability of a cause of action that was recognized in Lawrence and in Miranda, Your Honor.
You haven't addressed the issue of whether a mistrial should have been granted. Could you do so?
Briefly, Your Honor. The court, Your Honor is right that this is an abuse of discretion standard. The case law is strong and irrefuted that that jurors are presumed to follow instructions. In this case, the jury was immediately told to disregard. The trial court found there was no violation of a liminal order at all in terms of the testimony was offered. The court gave additionally another curative instruction at the close of the evidence, and the issue was negligence. That was made clear both in testimony from Mr. Bennett on the stand as an expert in questioning from counsel for the plaintiff of Mr. Bennett, and again in the court's instructions that this is a case about negligence. So every opportunity was, yes.
Witness, as you said, it was highly credentialed. Did your witness know about the motion in limine?
The witness did, and the record reflects that the witness was given the order of the court. And importantly, the court itself said there was not a violation of the motion in limine. In reviewing the case after the fact, the court did say, I don't find this evidence is relevant, and that's why I'm going to ask the jury to disregard the evidence, which it's presumed that the jury did in fact do.
Okay, thank you.
The fact that we are up here again talking about the overlap or not between PCR and negligence illustrates why that remark was so prejudicial. To talk about that, I want to think about a U.S. Supreme Court case called McCoy versus Louisiana. And that was a case in the PCR context, and it held it was ineffective assistance for a lawyer to tell the jury his client was guilty to assert diminished capacity or responsibility instead. Over the client's objection, the client insisted that he was innocent. And the evidence appeared there that he was in fact guilty overwhelmingly. But in a case where the evidence is not overwhelming and the lawyer still makes this call, I would say two things. Number one, I think that could be another example of rising to the level of illegitimate acts if all the other prerequisites of a criminal malaction are met. But it would also be a balance to this case in this way. McCoy involved the defense lawyer telling the jury over his client's objection that his client did it. This case involved Mark Bennett telling the jury over the state's objection, and despite knowing about the limine order and knowing that this was a fighting issue throughout the litigation to this point, that Robertson did it.
your friend on the other side just wrong about saying that Judge Bennett's comment was not a violation of the limine rule or ruling?
Specifically said that the PCR ruling was not relevant to the jury's independent decisions. If something is not relevant, of course, it's not even admissible. And the court also said in the limine order that too much information about the PCR ruling and proceeding would be confusing to the jury and run the risk of misleading them. The court was well aware that that was the state's concern about this evidence, and it agreed with that concern. And it also, it did not cite this case, but it mirrors the Oregon Court of Appeals case, which I think is Stevens, which involved this exact issue, and the trial court excluded all reference to the PCR ruling in that case, and the appellate court upheld it because, again, there is just such a danger in these unique cases that the jury will misuse it regardless of their instruction.
Did Houston help you where we reversed and ordered a new trial where the jury was told that in a child endangerment case that DHS had made a finding that the abuse was, they found it?
I think it does. And that key word is finding, right? That is also present here. And there's a difference. There is a material and prejudicial difference between background testimony that says PCR is a thing that happens and you can get a new trial, and a difference between Stephen Exley Schumann testifying, he said to me right after the trial, man, that wasn't very effective. I was ineffective. And the testimony from Mark Bennett saying he can't be here unless a judge already found. A judge made a finding, your job's done.
And there was an objection. Did the district court conclude that that did not, in fact, violate the motion in limine?
The district court read the limine order narrowly to refer to reference to the ruling and introduction of the ruling as evidence.
You said something about that the limine motion said something about too much information about the PCR?
Mentioned and encouraged the parties to agree on a statement of the case that included some limited background. Otherwise, the jury would rightfully wonder, why are we here? But wanted to stop short of saying it's already been found, ineffective assistance. I also want to go back.
Made a point, and I kind of highlighted the point I was getting at. If you conceive of this heightened standard of illegitimacy as related to the duty prong or the breach prong, how would you instruct the jury in the case where the plaintiff is seeking both pecuniary and emotional distress damages?
Add language, whether it's borrowing language from stock punitive instruction or borrowing language from Miranda talking about illegitimate, that says, do you find that the conduct was here?
Special interrogatory. Odd to have two different duties imposed on a lawyer in a single case. I mean, we can gauge conduct, we can judge intent, whether it's malicious for punitive purposes. But here, what you're saying is these are actually two different distinct legal duties. That seems very odd to me. I don't know of any situation where we do that.
Any situation where a plaintiff is seeking punitive damages, we give that instruction and we evaluate differing duties. I want to close with one example to answer your question, Chief Justice, which is another example of conduct that might qualify for illegitimate. It's the Wagonman case, which is the First Circuit case holding emotional distress damages are available. It involved malpractice so gross or obvious it didn't even need expert testimony, and the lawyer filed no pleadings on behalf of his client. I think that type of thing would qualify as well. We don't have that here, and that's why you should reverse. Thank you.